So starting September 2nd, that's 9 days from when this drops, three kinds of appeals are leaving the Merit Systems Protection Board: RIF appeals, suitability actions, and probationary terminations. So OPM finalized these rules at the beginning of August, and here's a detail that tells you a lot. Per government executives' count, about 1,250 comments came in on this RIF piece, and 99% of people said, don't do this. And they did it anyway.
And that's just a snippet from today's episode of Civil Rights for Civil Servants.
Welcome, everybody, to Civil Rights for Civil Servants. I'm Shaun Southworth, the founding partner of Southworth PC, one of your co-hosts. We represent federal employees nationwide before the EEOC, the MSPB, the Office of Special Counsel, and really anywhere your career gets decided. I personally have over 20,000 hours fighting for federal employees, and I've tried many cases to decision in front of the board that we're going inside today. I'm also a longtime mindfulness practitioner because protecting your career and protecting your peace, in my mind, go together.
And I'm Lydia Taylor. I'm the managing partner and co-owner of Southworth PC, and I get the privilege of running the day-to-day operations of our firm. I am an attorney for federal employees, and before that, I was an HR director for many various public institutions. So I've had the opportunity to sit on both sides of the table and get to understand how institutions think.
And then each episode, Lydia and I bring you the news that matters to your career in what we're calling the docket. And then one topic broken all the way down into things you can actually use in what we call the briefing. And then usually an interview with somebody worth hearing from in what we call the interview. And your questions answered in the Ask Shaun and Lydia Anything segment.
Awesome. So coming up today, 9 days from the day that this episode drops, Shaun, the board that hears fired federal employees' appeals loses a big chunk of its cases, and we'll tell you exactly what's moving and whether your case may be affected or not.
And then we're also taking you inside the board, the MSPB or the Merit Systems Protection Board, start to finish in a typical removal case. What happens when you file, the one right almost nobody uses, and what winning actually looks like.
And then the interview that we have been so excited to bring you guys. The attorney that is representing hundreds of fired USAID and State Department employees in front of that very board right now, and a USAID employee who is living it from the dismantling of that agency up till now. We'll also give you some information about how you can step in and help them.
And all of that will be covered today on Civil Rights for Civil Servants. And quickly, everybody, before we get going, just a reminder that this is an ad-free podcast sponsored by Southworth PC. So you're still not going to hear us talk about any crazy products, no toaster that also plays music, no yoga mat that doubles as a sleeping bag.
And I'm always going to ask the same simple favor of you guys. If you could just leave us a 5-star review wherever you listen to this show and share it with a coworker who needs to hear it. And as always, you can submit your questions for our Ask Shaun and Lydia segment. Just email us at advocate@southworthpc.com, or you can DM us on any of our social media platforms.
And one final quick note before we get started. The show is legal information. It is not legal advice. Every case is different, and listening doesn't make you our client. Hey, even if you are a client, we're not able to give you legal advice through a podcast. If something is happening to you at work, you might want to talk to a qualified lawyer about your specific situation. If you're a federal employee, you can reach our firm through attorneysforfederalemployees.com. So that said, let's get to work.
All right, let's jump in. So we're getting started with the docket today. Normally we do a couple of stories as part of the docket, but this week we've got one really big story. And I think not only is it tied directly to our topic, but it really does deserve our focused attention.
Yeah, it's pretty surprising what's happening. It's a big deal. So starting September 2nd, that's 9 days from when this drops, three kinds of appeals are leaving the Merit Systems Protection Board: RIF appeals, suitability actions, and probationary terminations. So instead of going to the independent board, the MSPB, those cases will be decided inside OPM. That's the government's own HR personnel office, mostly on paper, and the final word belongs to the OPM Director. So OPM finalized these rules at the beginning of August, and here's a detail that tells you a lot. Per government executives' count, about 1,250 comments came in on this RIF piece, and 99% of people said, don't do this. And they did it anyway. Now, to be fair, OPM has a stated reason. They say the board is way behind. By the board's own report, 20,000 plus appeals came in last year. about 4 times national. And OPM says in-house process will be faster. Or maybe they could just hire enough judges over at the MSPB and manage their case docket.
Yeah.
This is about consolidating power in a way that I think is problematic. The board itself put out its own rule on August 12th, basically saying, okay, well, our jurisdiction came from OPM's regulations. So they claim now they lack any discretion here, which I think is a very polite way of saying, don't look at us. Lydia, should we be heading for the hills right now? Is this something that should freak most federal employees out?
Absolutely not. So let's clear that up, Shaun, before anybody panics. While we want you to be aware of what is going to change, we really very clearly want you to be aware of what is not going to change. If you are a tenured employee and your agency removes you, demotes you, or suspends you for more than 14 days, your appeal rights are still heard before the MSPB. So that didn't change. This change is really specific. It's very tailored. It's about RIFs, suitability actions, and probationary cases. And even for those, the dates decide everything as far as whether or not it's something that can be heard before the board. The change does not affect, and I want to say this clearly and say it again, the change does not affect the vast majority of cases that we bring. And it is not going to affect the cases that are currently before the board. Vast majority of civil service protections still remain intact.
Exactly. Yeah. And so again, your typical discipline case not impacted, but if there's another riff, then this could come up. That's probably the thing that would affect most people.
And
And
probably the
again,
reason why this is coming up in the first place, Shaun.
exactly. I get worried about the suitability actions because if they want to retaliate against somebody, then they might try to put it through that lane intentionally as a carve out to cover up discrimination or retaliation. And I think people wonder is, well, what if I have a RIF case before the MSPB? What is going to happen to that case? And so those cases will stick before the MSPB. If your notice came before September 2nd and you file at the board before September 2nd, you're still at the board. So if people are holding a RIF notice right now, they need to get to the board before September 2nd.
Yeah.
On or after that, you're in the new OPM process. I think people wonder, what if my case lands in the new OPM process? Just like always, we would suggest you read the appeal rights paragraph in your paperwork the day it arrives, file it exactly where and when it says, save every page. The new process has its own clocks. So eventually we'll cover that in an upcoming episode. But Lydia, why do you think this shift matters fundamentally? PM will be like, oh, we're just moving it to a new location. Is that the end of the story, or why is this a big deal?
No, and you're right. I think that OPM may be downplaying it a bit, but here's why it matters more than probably how it sounds. When the people building a personnel file know that an independent judge might read it one day, they build a different kind of file. They're much more careful in the way that they build that file. And so when the review moves in house, the files tend to get thinner. That's just kind of human nature.
Yeah.
So the takeaway is the same thing that we have been saying since the first episode of this podcast. You've got to keep your own records as a federal employee. You have to be the custodian of your own file.
So, one quick thing to fit in here. I know we said only one story, but at the same time, the MSPB has been proposing changes to itself. They're proposing to retire the Douglas factors.
Yeah.
That's the checklist that's governed discipline penalties for 45 years. And I think we'll cover that more. And then the final thing, so it'll be Wednesday after this drops, the EEOC is going to hold a public hearing that I'm going to try to attend because they're proposing to change all of their stuff as well for the process. So as soon as we learn more, we'll know about that.
Important to just keep our eyes on these things. They're all changes right now, but they could definitely lead to bigger changes in the foreseeable future. So, per
Definitely.
usual, we're keeping our eyes on it.
Yep. That does it for the docket. Up next, we're going to have the a briefing, the case file, and then we'll have an interview. I think it's going to be really great. And then finally, we'll finish up with the Ask Shaun and Lydia Anything segment.
Yeah, and I think that this week's case file could really help someone who ends up before the MSPB or the Merit Systems Protections Board, Shaun. If you
Mhm.
know anyone like that, please share this information with them. Hopefully, you'll never have to go there, but if you do, it will be nice to have this information. Let's jump in.
All right, here we go. We got the case file, the briefing inside the MSPB appeal today. I've spent more of my life on that than anything else. Not literally true, but we know the MSPB really well. I think, Lydia, it's easy to forget most people have never seen inside of this one. So I think we should start. What is this? What is the MSPB? Again, the government's not creative about naming its stuff, like I say. So it's the Merit Systems Protection Board. It is the board that protects merit systems. It's tiny, right? I remember actually watching, I think it was 60 Minutes from CBS about how it was a small unknown agency. And I was like, not to me. It's like a
We
big
say
deal to
those
me.
letters more than we say our own names a good amount of the time.
I swear, yeah.
Yeah.
So a little bit of history about the MSPB. In 1978, Congress split what was called the Civil Service Commission into two. So OPM, the government's personnel office, and the Merit Systems Protection Board, which is supposed to be an independent board whose whole job is to answer one question: did the government follow its own rules when it acted against one of its own employees? And so that's why what's happening right now is historical, because it was split, Civil Service Commission, to OPM, to MSPB, and now they're trying to merge them back together in a way that's, I think, disadvantageous for federal employees and not structurally set up. But for the most part, when we go through the case file, we just want to focus on what the processing looks like for an average discipline case. And again, this is not changing. So most of it is still there. So
Yeah. And there are really two categories of people who should be leaning in for this conversation. Obviously, the targeted employee. If you are holding a removal decision, if you have a rift separation, if you're trying to figure out if your career is really over or in jeopardy, you should
mhm,
definitely be leaning into today's conversation. But also the union steward or the HR professional, because you're the one getting the phone call the night that it happens when an employee gets that letter and they're panicked and don't know what to do, usually the first person that they're calling is their union rep. So when you get that call, the next 30 days after you get that call are really pivotal. And this is information that you need to know in order to be able to help them through that. Remember when we talked about the EEOC, Shaun, a couple of episodes back, and we talked about all of the clocks that are involved with the EEO process. And for each door, there's a clock over it. Kind of the same principle applies here.
yeah, exactly. Same thing. Doors with clocks, but I'd say board's map has fewer doors, but the clocks are shorter and the stakes are bigger. So people need to watch that. When we went through the EEO episode, there's a whole bunch of different stages with clocks, fewer clocks for the MSPB, but miss it and it's over. So let's walk through them then. Who can
Yeah.
appeal? What happens when you file, discovery, the hearing, how these cases actually end. So
Yeah.
let's go ahead and get going. Lydia, let's talk about step one: who can appeal on the 30-day door. What do you think feds most need to know about this?
Yeah. So obviously, the very first thing that an employee would need to know is, do I have access to this board? Who
Mhm.
is this board for? So the classic board appeal belongs to a tenured employee, somebody who has passed probation, who is hit with one of those big personnel actions like a removal, a demotion, a suspension of more than 14 days. And that door has a clock over it. It's generally 30 calendar days from the effective date of the action. So if you receive the letter on, let's say, August 25th, and the letter says effective immediately, then August 25th is the date that you start that 30-day clock. Now, if that letter has an effective date in it that is different than the date at the top of the letter, then that effective date is the date that you want to use. And keep in mind that weekends do count. We are talking about calendar days and not business days. Okay. So the first thing that you are going to do is you are going to file online through the board's e-appeal system. And here's what I need you to understand about that process, because this is where a lot of cases die. You do not need a lawyer to file, guys. And we are lawyers telling you that. If you are up against that deadline, please go onto the e-appeal system and get your case filed. You do not need to start gathering evidence. You don't need to do anything but just get that process started. The appeal itself is what affects your rights. The lawyer and the evidence, that can all come after the appeal is filed. What can't happen is that you wait to speak to a lawyer or you wait to gather evidence and you get to day 31. A lawyer's not going to be able to help you to get that appeal filed.
And just like everything we say, there's always an exception that we might be able to help you, but we only got 14 more days. So what happens if it's day 31? Most people, you're out of luck.
Yeah.
unless you miraculously have an EEO claim. If you have an EEO claim, you can start at the EEO if it's still within 45 days
Yeah.
and you can get back to the board there. But you don't want to mess around, like you said, with those deadlines. You don't have to have your evidence gathered. I think people think, oh, it's got to be perfect. No, what you do have to do is stop the clock.
Yeah.
We've had more than one person call in, but I remember one that called us on day 29 apologizing, saying, hey, probably too late, right? At that time, that was many years ago. We filed at night, short, rough, and on time. So it was perfectly fine, no impact to their case. That case had a chance because of what was like a 40-minute filing on day 29. Filed and perfect, but it doesn't matter because you can adjust the stuff later. Now, that said, we've changed a little bit just because we've grown. So now we are asking people to contact us soon. Please don't wait. But once you retain us, we need at least 48 hours to make a filing like this. We know a lot is going through your mind when this happens emotionally, just from our experience. That's why it's great if people are watching our podcast, just so they know it might trigger something like, oop, I got to move quickly. That's like the key takeaway.
Yep, absolutely true. So, all right, Shaun, we have gone on the e-appeal system. We have filed the appeal. Let's talk about the next step. You file. So now the burden flips. What happens after that?
Great. So you filed. What's going to happen is an administrative judge is going to be assigned. And then one of the first things you'll receive, usually in a few days, is something called an acknowledgement order.
Okay.
And here's the tip I would give every single client on day one, and everybody listening should know if this happens to you. Read every single order from your judge very carefully
Yeah.
every time. I would print it out or put it on the screen, and I would write a pen mark through it and read every sentence very slowly and carefully, maybe read it 3, 4 times. This is not just a document that you read and understand all of it at first. It's going to be dense and complicated. Judges do run their cases differently. The deadlines inside these orders are real. If you miss one, you might not even get discovery, which we'll talk about later.
Yeah.
And cases can get dismissed for ignoring them faster than people realize.
Yeah. It's essentially your roadmap through the process.
Yeah. Now, here is the part that is great to know about these when this gets going. And this surprises almost everybody. If you manage to, like you said, meet that deadline, at this point, the burden is going to flip.
Yeah.
And that's the thing. The agency has to prove your removal. They have to prove the charges against you. The agency's going to go first and the agency has the burden. So again, just by getting through the door, now they actually prove them with evidence by what's called preponderance, which means more likely than not. So you don't have to prove you're innocent. They have to prove that they're right.
Yeah. Now, what we also want our listeners to know is that if you have a RIF appeal, if you are appealing a reduction in force, it works a little bit differently. But honestly, I think it's even better for the employee because a RIF isn't supposed to be a judgment about you. It's supposed to be a formula. Retention registers, competitive levels, your tenure, your veterans preference, your rating. So a RIF appeal is really just an audit. Did the agency run its own math correctly? Did they follow the rules and the regulations? And the math is wrong, honestly, Shaun, more than people realize that it is. Formulas get run by humans under deadlines, under pressure, in bulk. And I can tell you from my own experience that facilitating a RIF, administrating a RIF, is a really complicated process. And yes, the math is often wrong. So at least that's the case when it's a bona fide RIF. But many of the RIFs last year that the federal government experienced, that federal employees experienced, were probably not bona fide RIFs.
So it's more complicated, basically. But like you said, there could be a lot of errors. So that's, I think, what was notable about last year's RIFs in
Yeah.
particular. We were trying to spot the ones where they did. And I think you and I had discussed this before, but one of our clients who was in HR too, they said this RIF process normally would have taken them 6 to 9 months to do it
It is
right.
absolutely true.
And they were getting these out in weeks, days in some
Yeah.
instances.
Yeah.
So one other thing, though, I did want to add. So at this stage, we talked about the burden. It's not the burden on everything; it's the main stuff. But there's something called affirmative defenses we wanted to talk about. So people are going through that. You might want to raise them.
Yeah.
Things like discrimination, retaliation from whistleblowing, or they denied you due process along the way. Those things we call them affirmative defenses because if you raise them, you have the burden to do that. So
Right.
again, even if the agency proved a charge, it still not be done.
Okay. So what happens after you get the acknowledgement order once your case is progressing towards being heard by a judge? What's step 3? What comes up next?
Yeah, so the next step is one of my favorite parts, which is discovery. I generally think it's probably the most underrated right a federal employee has. So let's slow down for it a bit. So, what is discovery? Discovery means that once your appeal is moving, the agency has to answer your questions in writing under oath. You can start asking them questions. You can make them turn over documents, categories of documents. It's complicated about how that actually works, but a lot of emails, drafts, comparator files, if they're relevant, that's why it's great to have an attorney. But irrelevant things, you should be able to make them turn over. And at that point, you can take depositions, which means the people who made the decision sit across from you or your lawyer, answer questions under oath and on the record.
Yeah. So the difference, Shaun, between maybe what you were experiencing with your supervisors prior to this process is that every internal review, every meeting where you were told, we'll look into it. If you asked, well, can I see what you put on my PIP or can I see the notes that you took about me in that meeting? And you may hear something like, oh, we'll see if we can find that. We'll look into it. The difference in discovery is that this request is compelled by a judge. So,
Mm,
for this moment, you could never really know whether they were actually looking into it, whether there was actually any intent to produce that for you. But now we have a judge that is overseeing the process and making sure that it gets done. So, I've spent years, Shaun, building these files. I
mhm.
was a litigation support specialist for the Department of Justice for a while, and I also am a certified EEO investigator, so I know what it looks like to build files. And I will tell you that the agency files that they show you at the beginning is almost never the whole story. And that's why the discovery process is probably Shaun's favorite and why it is so important to the process of building your case.
Yeah, and I agree. I've never built the files on the inside like you have, but I've seen them come across our desk, and almost never is right. I hate saying never because I'm a lawyer, but I would almost want to say never
Yeah.
because there's so much that we can learn from this. And again, like you said, this is like before, if you're talking to HR, they're like, here, we'll go try to get that for you, maybe. Now it's like, okay, you got to turn over and show your cards. So I would say I don't think I've ever had a case where discovery didn't change the picture, at least somewhat. Somebody's email, somebody's earlier draft, somebody's text message. A lot of people contact us. We are looking to see if they have what we call indicia of discrimination, retaliation in some cases. We don't know where all this stuff is, all the evidence is, but eventually, if you have an attorney, you can get it right. So this is, I think, links back into what we were talking about at the top, Lydia. This is why I'm most concerned about stuff going from MSPB to OPM,
Yeah.
because that new process for OPM. What about discovery there? No discovery,
There's
right?
no discovery.
No depositions,
Exactly.
no subpoenas.
Yeah.
So imagine that for the rifts that happened last year. We know a whole bunch of stuff's wrong, but now they don't have to turn over information about it. Tell me how that's fair.
Yeah.
So,
And this is exactly why. Do you think they're tired of hearing me say it yet, Shaun? This is exactly why we tell you to keep your own file. And I know that I sound like a broken record, but it is one of the most imperative things that you can do as a federal employee. So, after discovery, Shaun, once the agency and the employee, either if they're working pro se or they're working through an attorney, after they've exchanged the documents and asked each other all the questions that they want to ask in the discovery process, we move on to step 4, which is the hearing. So, kind of talk us through what that looks like.
yeah, so I have a lot of experience here. I think in 2023, I was doing like 3 hearings a month. It was a little ridiculous, but yeah, this is where you got some real inside baseball knowledge for everybody. I said I like discovery because I like to win cases, but my favorite part is hearing. That's when you get people to tell on themselves without them realizing it. It's fun. So here's kind of what people need to know just in general. First, the hearing itself. People picture a courtroom TV. It's not like that. It's usually over video now. It's Zoom Gov. It's usually just you, your representative, the agency's lawyer, the witnesses, and the judge. There's no jury here. The judge is going to make the decisions. The judge, it's not like a judge you would see on TV where they're trying to say which side is right. The judge is an administrative judge, a federal employee. They're supposed to be getting it right. Like their job is to figure out what happened and to develop a record. Now, the other witnesses are usually barred from watching your testimony. If it's your case, you usually get to watch all of the testimony and you usually go last. But one thing that is a quirk about this is that this is public. So it's
Yeah.
open to the public. People don't usually show up, but when we were talking about EEO hearings, we mentioned to everybody those are private, so public can't show up. But a board hearing is the opposite. So most days nobody shows up. I can't think of a single time I've had someone show up because it's
No.
not well publicized, but they theoretically could.
Yeah.
So what happens during the hearing, witnesses will testify under oath, your side and their side, there's cross-examination. And the judge is essentially doing one thing the entire time, deciding who to believe. Is the story consistent? Is it plausible? Applying legal rules to determine what facts they're going to find. Does the paper back someone's testimony up? Does it contradict them? What's the witness's motive and all of this? And I think this is where hearings turn. And honestly, you don't know what's going to happen until you go through a hearing because things
It's
can
true.
change. But usually, what I think changes it is people being confronted after they testify. They confidently tell a story. I'll be like, oh, keep telling me that. Oh, look at this email. This kind of contradicts exactly what you just said. And
Yeah.
so that's where it really changes outcomes. So,
Yeah. And this is why it's so important to be prepared,
yeah.
to be properly prepped before you go into a hearing. We've done plenty of MSPB hearings, and we have seen the agency's witnesses show up, and we can tell the difference between a witness that has been well prepared and a witness that is not prepared. Those that have been prepared handle that confrontation a lot better than those who have not. We've often heard clients come to us and say, I don't need to be prepped. I know what happened better than anybody does, or I just want to get up there and tell my story. That is not a sound plan.
Yeah.
'Cause
No, please don't
that
do
is
that.
not often what happens. Your
Mhm.
story needs support. And this is not to invalidate your story, but when you are walking into that setting, your story needs support. It needs exhibits, it needs timelines. We have to have the record intact and in place as we're going through that process to be able to support your story. And sometimes our clients get the benefit of being more prepared than the agency witnesses do because we are very intentional about the time that we take in getting our clients prepared for their testimony.
I think that's one benefit of having an attorney also. You can do this on your own, but you need to be super prepared if you're doing it on their own, like 3, 4 times more than you think. Because the thing that makes it harder to do this on your own is you've been affected by this, maybe traumatically.
Yeah.
They say a lawyer who represents themselves has a fool for a lawyer because it's so hard to objectively see stuff.
Yeah.
But then you could be affected as you see stuff. Like if somebody starts to lie, are you going to have enough calm, cool collectedness to be like, oh, let me continue to get you out there to commit to this? Or are you going to get triggered or something? Right.
Yeah.
Yeah.
And I just want to say in the lane of preparation, Shaun, it's almost impossible as the employee to walk into this experience unemotional, right? Your job has been taken away, or you've
Mhm.
been wrongly accused and demoted or suspended as a result. The one thing that combats showing up emotionally on the stand is being prepared,
Mhm.
is walking through that emotion with your representative before you actually show up in front of a judge. So never underestimate the importance of preparing before you go into that process. It's really important.
Yeah. And that's why when we work with our clients, we start preparation from the beginning. I know sometimes clients will say most of people are great, but we see different things where it's exhausting for people to go over their story and they're like, why do I have to tell you guys this again? I already told you one time. But we are subtly, as part of our process, trying to have them go over stuff to
Exactly.
make sure it stays in their mind. And you know what? The other thing I wanted to emphasize, I love hearings, Lydia. It's so much fun
I
because
know
some
you do.
crazy stuff has happened. In fact, I want to tell everybody right now about that one thing happened. And
Um,
then we ended up at Zocalo's in Midtown, Georgia, having a margarita because that thing happened. And that's one of many hearing stories we have. You
yeah,
don't really know what's
where
going to
the
happen until
client
you
showed
get
up
there.
emotional and it was a train wreck.
Yes. And for privilege, that's all we're going to
That is
say.
all
But
we're going to
I guarantee you, if
yeah,
you're listening to this, you are not anticipating what we mean by train wreck. And again, most people are good.
yeah,
That's why I like representing federal employees in general, because a lot of them are very truthful, honest, great people. So,
absolutely. So let's talk about what this all looks like after the hearing, Shaun. The
yeah.
judge is going to make a decision, right? So This is where we can really see that the board has real teeth. There's
Mhm,
real influence that comes from these decisions. You can be reinstated to your
mhm.
position. That removal goes away. You can get back pay with interest, your benefits and your records restored. And the agency is required in most cases to pay your attorney's fees as well. So the law calls this putting you back where you would have been. It's the judge's job, assuming that they find in your favor, to make it like this whole thing never happened.
I think one of the things the agency is concerned about is what happens if someone wins. They can be ordered back to the job, but to show everybody how much teeth and how right you were, Lydia, what if that position no longer exists? Can someone still be placed back into a position?
Yeah, and we've had that happen. Sometimes the MSPB process can be long. By the time we get to the end of it, maybe that entire position has been eliminated. No, the agency is required to recreate that position for you and put you back in that position, put you back in a situation as though this never happened.
As close as possible, and sometimes
Yeah.
it makes them very uncomfortable to do that.
It usually does. I haven't seen a situation where it does not make them uncomfortable to do that. So you're
Yeah.
absolutely right. But the honest truth, Shaun, is that most of our cases never get to a judge's decision. Very often, our cases settle. I remember a case very early on in my tenure with the firm, an employee who lost his job after 30 years. And we were going through the process. We went through the e appeal, we went through the acknowledgement order and discovery. And in the midst of all of that, a tragedy struck his family. And he came to me and said, Lydia, I am tired of fighting. I don't have the strength to keep going with this. I really just want to end this with some dignity for myself and my family. And ultimately, what we ended up doing was settling with the agency to get him a clean SF-50, to get him at least some of the back pay that he lost, as well as getting his attorney's fees covered. And sometimes, Shaun, the win is not in the decision. The win is restoring peace to the life of that employee. And that does not always include going back to the agency, getting your job back. Sometimes that means bringing this chapter to a close with some dignity and with some respect and with at least some of what you deserve.
Yeah, that is exactly right. That's actually one of our values people don't think about.
Yeah,
One of our values is that we are client focused. So it doesn't mean we can get you everything you want all of the time,
yeah,
but it does mean that we can promise to know what you want and try to drive for your objectives, when to fight, when to stop fighting,
yeah.
with strategy to try to get you there. For our clients, they can imagine they're the president of the United States and we're their generals. So they can tell us what they want, their aspiration. But if they're unrealistic, we need to say that. But we still have this obligation to try to fight to get them there and to act strategically. Some of the best things about this is being able to help someone. Litigation is a battle, so it's not always favorable
Nor
or easy. It's not easy, but we can help people through that.
okay.
So, to your point about settlement, Lydia, that's why our approach from our team, we build for the hearing, but
Yeah,
we stay open to the exit. One of the things with federal agencies, they're not as cost sensitive as private sector employers because the cost of defense doesn't really apply to them. So they can push you a long way. But one of the benefits of working with us is you have a whole team to help figure out the best moment to try to resolve it based on your goals. And that's why we have members of our team many are former feds, which is great. We also have people who've been on the other side, which helps us understand what the other side is thinking when it's not a mystery to us. Usually the agency's lawyer is asking, hey, can we actually prove this? Will this file survive a neutral judge? What happens if we can't win this? And so whenever you have a case that makes those questions uncomfortable, that's usually when the phone rings, and it can happen right before hearing, can happen a little bit before hearing. It's happened in the middle of hearing. We've had judges stop the proceedings and tell the agency they need to
yeah, yep.
go settle.
Go
So,
go talk this over some more.
and so given all of that, that's where I'd say, can you do this alone? Yeah, you can file alone, but the more important it is,
Yeah,
even if you are a lawyer yourself, if you're an agency lawyer, you'd probably use us because again,
absolutely.
you need someone objectively fighting for you.
Absolutely agree. So if we were to boil this down, Shaun, because we just gave them a lot of information. If you only keep a few things from today, Shaun, what do you think is the first and most important takeaway that our listeners should take today?
Yeah, I think it's what you started with, your point, 30 days.
Yeah.
30 days. That's the emergency 30 days. Again, many people are going to watch this that will never need this, but some will need it. And they, between now and then, maybe 10 years will pass, 30 days. If you remember one thing, 30 days. What beyond that, Lydia, would you say is the next thing from what we discussed today you think that people should take away?
Yes, the burden is not yours. The burden on
Yes.
the agency. The agency has to prove its case. And a RIF appeal is an audit of their own math. So don't assume that the paperwork is right just because it all looks official. And keep in mind that it is not your job to prove that they are wrong. It is their job to prove that they are right.
Yeah, that's great. And then the next one I would say, so we got date, the burden. Third thing is, hey, discovery is a thing. It can be your superpower. It's
Yeah.
the one place, this whole story where the agency has to answer your questions under oath, and you can find out more about what actually happened and whether they can prove the stuff. Because before then, they're just assembling it behind the scenes. You never know exactly what's happening. What, Lydia, would you say is next big takeaway?
I would say keep in mind that, guys, these fights usually do end in agreements. Okay. So you build as though you're going to a hearing, but you negotiate from a position of strength and never fear. If the case really matters to you, though, please get an attorney. As Shaun said, even if you are an attorney yourself, the best thing that you can do is get someone objective and someone who is an expert in this field. So if you are protecting a tenured career, get someone to help you with it.
Perfect. There we go. That's the roadmap. 30 days. The burden's on them. Discovery is your superpower. It's going to often end in an agreement. You need to negotiate from strength, not fear. And that is the case file for today. And perfect transition coming up here. Now we're going to talk to a man litigating this map at a scale on behalf of USAID employees and one of the USAID employees who's been impacted by this. All that's coming up next on the interview. Our guest today has spent more than 35 years as a litigator. He started out as a Navy JAG, became a federal prosecutor in Washington, worked at the Justice Department, and has tried more than 150 cases to juries, along with more administrative board proceedings than anyone can count. And since the earliest day of the USAID dismantling, he has been representing hundreds of separated USAID and State Department employees before the Merit Systems Protection Board. Kevin Burns, welcome to Civil Rights for Civil Servants. Also joining us is Lillian of the USAID Employee Support Fund, a career USAID employee herself. The fund was built by USAID people for USAID people. It connects separated foreign service and civil service employees with legal representation, helps coordinate their cases, and gives hundreds of scattered employees one collective voice. Lillian, also welcome to the show. Kevin, wanted to start with you. Today's episode that you're on, we have been walking through for federal employees generally how appeal goes before the Merit Systems Protection Board. I know it's a small board that you probably know a bunch about. So I kind of wanted to start with that. For listeners who've never had to appear before it, what is the Merit Systems Protection Board and what was it created to do?
Well, first of all, thanks for inviting me, Shaun. It's a pleasure to be here, and thank you for that wonderful introduction. So, in 1977, Jimmy Carter signed legislation that Congress had passed that created the Civil Service Reform Act. And what it did was it took a hodgepodge of federal rules and regulations for various agencies and it codified them through Congress. The underpinning of the Civil Service Reform Act, which is right in its actual language, was to create a merit system based federal service that employees would be judged on merit and on objective criteria. And those employees would swear an oath to the Constitution, but not to any particular man or woman. And it would eradicate what was perceived to be the cronyism that existed, particularly under the Nixon administration with some of the excesses that were perceived in presidential power. So the Civil Service Reform Act created the Merit System Principles, which were a group of 12 principles that were to guide how federal employees were to perform their duties and be adjudged for any conduct or performance deficiencies. It created the Office of Special Counsel, which was supposed to protect whistleblowers and actually be their advocate. And then it created the Merit System Protection Board, which was supposed to be a board of independent administrative judges who would review federal civil service and later foreign service employees who were appealing conduct or performance issues that they felt violated in some way, shape, or form the merit system principles. And that was created in 1978. So the original idea before the board was the board would be an alternative to the courts. You would have a quick, expeditious, relatively low-cost mechanism for employees to grieve their allegations of either whistleblower reprisal to the Office of Special Counsel, or they could bring actions to the board if it was a conduct or performance-based action that they felt had some way violated these principles. And so that board was created, and within a few years, however, the board was almost captured by the administrative agencies it was designed to control, beginning in 1981 and continuing onward up really for the next 20 years or so. The board rapidly became not only a mechanism that did not do what I think it was originally designed to do, but became almost slavish to the idea of the efficiency of the federal service and focused almost exclusively on whether the removal or punishment of employee was, quote, efficient for the federal service. And in that way, they gravitated over time to heavily support management in their analysis of cases. So for federal employees who have a conduct or performance issue, board procedure developed over time, and it was an amalgam of the federal rules of civil procedure, which set out some fairly specific ways that you produce evidence, and what is called an appellate practice, because you bring an appeal to the board. Now, the problem for federal employees is that this is a complicated process. On paper, any federal employee who believes that a conduct or performance issue that's a major issue, that is something that has more than a 14-day suspension, is a product of whistleblower reprisal, involves a termination, can simply file an appeal to the board that says, I want to appeal this to the board. But in the process of the board handling that, they developed a very complicated, arcane system of presenting an appeal. And it is not for the unwary to venture into. And many federal employees who have gone into the board as what we call pro se or representing themselves have found the procedures daunting, the board's body of law somewhat having a thumb on the scale for management, and not being sort of the rapid, expeditious procedure that it was originally designed to be.
I've only been representing federal employees before the board for about 15 years now, but it was great to connect back to when you were talking about the Civil Service Reform Act, when it was founded. I think that's helpful for people to know. I was wondering from your perspective, since you've been doing this for a while, there's been some changes, right? And I think it was reported that the board is dropping the word independent from its own website, for instance, and they're finalizing a rule moving RIF, probationary, and suitability appeals over to OPM as of September 2nd. So, as someone who has litigated and helped federal employees before the board in the past year or so, are there any changes to the board that stand out to you? And how would you describe overall what you think is happening at the board right now?
Well, from my perspective as a lawyer who's practiced for the board at least for 25 years, the board has never been sympathetic to the federal employees. It tends to support management. There were analyses that were done 10 years ago where the board was deciding 89% of cases in favor of management.
Mhm.
And when it came to cases that involved allegations of discrimination or whistleblower reprisal, that rose to almost 98%. Now, that was a bit misleading because many strong cases before the board settled.
Exactly.
So,
Yep.
so when faced with a difficult challenge or a questionable challenge, sometimes board judges were very good about saying, look, I'm looking at this case and I don't think it's going to go your way. You should discuss settlement. So when the new administration came into power, it relied on Project 2025's vision for the realignment of the entire federal employment sector. The idea was that federal employees had been an anathema to the first Trump administration. And so Russell Vogt became temporarily the head of OPM and is now the head of the Office of Management and Budget. Scott Cooper, who was the head of personnel management, they began instituting policies to implement what is loosely known in the legal field as the unitary executive theory.
Exactly.
So those of your federal employees are like, what does that mean? Here's what it means. The vision of these folks is that the Civil Service Reform Act needs to essentially be abolished. And we need to return to a system where the president is the CEO and manager of the executive branch, and you work for the president. And so all of the regulatory changes and the substantive changes that have occurred since the last year have as a common theme the desire to grant the executive almost an at-will power over federal employees. So this is the core issue for all of this. The Supreme Court has ruled repeatedly that federal employment is a property right. Now,
Yeah.
the reason the court did that is that supports the idea that a federal employee is not a mere employee of a private entity. They are a civil servant that serves the Constitution and the American people. And so, in order to enhance and empower them to protect their rights against management that could be swayed by political or other objectives, they have a right in their property. That right cannot be denied without due process. The due process was to be incorporated into the merit systems and the merit system board practice. Early on, the president fired all of the independent board members, all of the Democratic members. In the first Trump administration, he just left the board vacant, and that caused a backlog of thousands of cases. In the current iteration of the administration's policies, they have basically attacked the independence of the board. And they have said the board now is subordinate to the executive branch. And in fact, its case law will follow the directives of the executive branch to the Department of Justice. They shifted the rules about probationary employees. They took away probationary employees' right to go to the board generally. They changed the senior executive service criteria to have more of a political, ideological loyalty test where they could ask questions about that. And they have been attempting to undermine the strength of the Civil Service Reform Act by transferring functions away from the board to the Office of Personnel Management, which will be perceived as much friendlier to the administration. And the goal is ultimately to remove the statutory protections that you have as a property interest and to render you almost what's called an at-will employee. For those of you who don't know, under the United States system of labor, at-will employment was originally designed to protect workers' rights to just quit a job, not have indentured servitude. That changed to where you get paid a day's wage for a day's work and you can be terminated for any reason. The only variation now is that reason cannot violate the Civil Rights Act or some other act of Congress. I represent Mary Comans, who was at DHS, who recently won a victory over her getting fired by the administration based upon false allegations brought by Lauren Loomer. I have the USAID workers. I have the State Department workers at the Intelligence Manipulation and Interference branch that was abolished. All of these terminations have one thing in common. They are all based on the idea that the president and his appointees have unlimited power over federal employees. The reason this is so significant for both employees and for the public in general is it undermines and negates the entire concept of the Civil Service Reform Act. The goal is to reduce that objective merit system-based federal workforce and to make employees responsible not to a larger set of principles, but to the directives of the president.
Yeah, and I want to agree with a lot of what you're saying, pretty much everything here. And it's very interesting as, two practitioners to get into this. I want to talk about some of the USAID cases in particular. Before we get into the cases, though, I wanted to set the table for listeners from what public reporting shows. So this is my take from the outside. According to reporting in early 2025, USAID, it looks like, was the first agency taken apart. Thousands of employees locked out or put out on leave within weeks. But July 1st of last year, the agency formally ceased to exist with a workforce of more than 10,000 cut down to a skeleton crew, most of its programs terminated. Foreign service families posted overseas were given a matter of weeks to pack up their lives and get home. And I think the toll is still showing up in the data. Just weeks ago, I was reading the government executive. There was a survey of nearly 4,000 former foreign aid staffers. Among the foreign service officers who responded, nearly half lost both household incomes at once. Only about 40% have found full-time work, and 81% reported stress-related physical symptoms. So that's in my mind, at least from public reporting, what I'm seeing the background. But without getting into anything you don't want to, because I know these cases are still in litigation, can you describe the range of cases that Patriots Law is supporting for USAID?
So what happened is there was a move to basically unilaterally abolish USAID. And it was part of the administration's move to do everything from challenge the power of federal employee unions to represent their employees to impose what's called Article 2, which is on senior people that could be fired without any rights. It was the first action of the misnamed DOGE, the Department of Government Efficiency, which, like the Holy Roman Empire, was neither a department, nor was it of the government, nor was it efficient. But what happened is they came in and they sent vast majority of employees on administrative leave. The first thing they did was try to gain access to employee records. These were DOGE people. They were not appointees. They came in, that some of them were 22, 23, 19 years old. When senior executives at USAID resisted that, they fired them. And they were fired by Elon Musk, which raised an interesting issue because technically he's not a federal employee nor federal supervisor. They were fired, and then everyone was sent home on administrative leave. The administrative leave lasted to July and September, about 5 months to 7 months of administrative leave for about 5,000 employees. You're talking about a loss to the taxpayer of hundreds of millions of dollars. In the meantime, the functions of USAID simply stopped. The manner in which it was done was particularly cruel. And in fact, I believe the cruelty was intentional. Musk appeared with his chainsaw, went on TV, made public appearances talking about how he had destroyed USAID for reasons nobody can quite follow. There were allegations that USAID was engaged in some sort of political activity. So the entire agency was not closed because only Congress could do that. So they still have some employees, but the entire agency was placed on what we call administrative leave. In January 16th, 2025, 4 days before the administration took power, Congress imposed the new Administrative Leave Act, which limited leave to 10 days without a series of things. And the reason they did that is because in the past, agencies had misused administrative leave as a disciplinary tactic. They would send people out until they quit. And I have cases with the Central Intelligence Agency right now where a fair number of employees have been on administrative leave with pay since February of 2025. And there are other reasons why they have not been terminated that have to do with national security and other issues. But so with the USAID, what happened was they came in and they put almost the entire agency on administrative leave and they fired all the managers. And then they had this round robin of political appointees and DOGE officials that were going in, sending notices from no one, telling people that they were on administrative leave. There was a big show of going to the headquarters and taking down the sign, defenestrating the agency and making a public spectacle, giving people 4 hours to gather their stuff. This was gleefully done. Okay, this was not some sort of thought out administrative process where somebody calculated this agency was not performing functions we needed and made a decision to reorganize that agency. Reorganizations happen all the time. Companies do it. They have to let people go. There are procedures that have to be followed. In the government, they do it through what's called a reduction in force. The only other major reduction in force was under William Jefferson Clinton. That took 2 years, and there were goals to reassign and reallocate employees because you had a tremendous body of federal knowledge and experience that you wanted to protect and preserve. For instance, the Department of Justice used to have a Nazi hunting unit. At some point, the Nazis were becoming 100 years old, and they needed to reorganize that division. They would normally tell the employees there, like, we're going to send you somewhere else because we no longer need this unit. In this particular case, what they did was they just sent everybody on admin leave, and they have statements where they were contemplating firing them, but they didn't know how to do it. So Russell Vogt came in and tried to say that he and OPM could manipulate the administrative leave period, and he issued hasty regulations saying that you could put people on administrative leave for extended periods pending a reduction in force or their termination. Now, we don't think that's legal, and we have alleged that it's not. MSPB, using its pre-2025 experience, has said that's not a cause of action, but it is evidence of potential misconduct. In February, I got calls from people at USAID that had been reassured by no less than Marco Rubio that all of this would not happen, that basically this was DOGE being out of control, we'd take care of it. That did not turn out to be the case. And so when the employees came to me, I saw this for what it was. This was going to be a mass termination done, a sort of shock and awe against federal employees to drive home to them that under the new management, they had no rights and they were not going to be able to do anything about this. And so the public stage and the public theater were designed to emphasize to federal employees, particularly those in USAID, that you are done. What bothered me about this was, regardless of the politics, because I'm not into the politics of it, people vote for who they vote for, administrations have priorities. What bothered me about it was the lack of due process, the lack of procedural and substantive rights that employees were being given. That was one part of it. The second part was what I saw, the gross violations of law themselves. And the third was what I saw as the absolute cruelty that was being inflicted on these employees. I've done many years. The last big case I did before USAID was the sexual harassments and sexual assault cases out of the Central Intelligence Agency. And I've represented combat veterans, and half my clients were law enforcement agents. And what I saw was an intentional cruelty that rose to the level that if an individual supervisor had done this to an individual employee, the only question was, would this be actionable harassment in the civil sector, or could I bring a criminal case? And that was the issue we had with some of the sexual assault and harassment actions in the CIA. So I saw a very similar pattern here where the cruelty was the point. The theater was the point. The idea was to, in the words of Russell Vogt, terrorize the federal workforce. And so USAID, most Americans were like, we don't know what they do, right? And there was this drumbeat against them that they're engaging in all this illegal activity. And like any other agency, mistakes are made, and some people may take the mission a little too far here and there. By and large, the agency, which was created by John F. Kennedy, was designed to win the hearts and minds and basically be a force for good overseas and have two aspects of it. One is the idea of assisting countries in dealing with things like water and political issues and environmental issues and all of those things that we express interest in. And the second portion of USAID's mission was, in all candor, to be a sort of soft power, to project American values overseas and to make sure that we were in Africa, we were in Asia, and not our adversaries. And so when USAID was shut down, the effect on the people they were serving was immediate, dramatic, and in some cases deadly. And when they came to me, I saw this, and what I decided to do was to bring cases to the federal circuit or to the U.S. District Court where that was appropriate, because these forums were far friendlier to employees. They also had far more concerns about due process and procedural and substantive rights. And many times in my career, I would go to the board almost to just build a record, knowing that my ultimate objective was to get before a district court or the federal circuit. And that has been an effective strategy. So when I saw this, there was this immediate reaction where well-meaning law firms and the unions decided that they would go and file class actions. Having been before the board and having spoken to the chief administrative law judge when this started, I knew that wasn't going to happen. And I did take a position that was different than that. And I said, no, we're going to have to do a group appeal, which I had some experience with, because the board will not take a class action for an employment-based case. We contacted the administrative judges that we were going to file cases in front of, mapped out our strategy, preserved our argument on the administrative leave, and then began canvassing the employees. And a lot of employees were frightened. There was a hope among many of the supporters of USAID that they would either get some sort of congressional assistance or the law firms would do pro bono work and win the day through these class actions. MSPB appeals are very laborious. They cannot be done cheaply. You need to treat it like a trial, especially when you're challenging an entire administration. I knew it was going to be a prodigious task. I also knew that federal employees generally cannot afford to spend on their own in an MSPB appeal. I've had MSPB appeals that have run $65,000 to $150,000. Most federal employees, particularly those who are getting fired, don't have the resources. So we came up with sort of a group process where we would have a group effort and we would combine the claims and resources of individuals and move forward. And the thing that I saw initially was the manner in which you were going to have to attack what happened was to challenge the idea that the reduction in force and the administrative leave were ever even valid.
Yeah.
You could not accept the premise, and many of the unions and law firms wanted to challenge the procedures by which the RIF and other things were done. And understandably, most practitioners in this area, they're either former government employees or they've worked for government agencies in some way, shape, or form as lawyers. They become very procedurally oriented. I wanted to challenge the substance of the RIF as illegal, what we say in Latin, ab initio, from the outset, that it was an improper action for an improper purpose done for malicious reasons. And so we gathered the employees together, and that's what we filed. We attacked the reduction in force, and we continue to attack it as a sham. Our basic premise is the reason that what the government is doing is wrong in all of these cases is because it's projecting onto the employee the political motivations or orientation of the policies that were in place. So the theme in every case I have, every agency where it's something to do with the administration terminating an employee, there's one constant theme in all of this, which is the transposition to the employee that you are engaged in misconduct because your ideology opposed us. We believe that USAID, as Stephen Miller said, was 98% Democratic and radical progressive voters. He said that publicly. Other statements came out and said that USAID was woke and all this. So this was seen as a culture war issue. It was seen as something where the employee themselves, to their core, opposed our view of government, our policy. Therefore, it wasn't merely ending the policy. We needed to terminate the employee. And that has been the thing I've raised in every single case that I brought since the administration came into power, that the conflation between what you did and what you believe. If the administration had come in and said to USAID, we're not going to offer any aid to Uganda anymore. We don't like the government. Or if they had said, we're just not going to do water projects. We're going to focus on religious freedom in Nigeria. And nobody had been fired. My response to that as a practitioner would be, that's their prerogative. So the issue for me has always been, and this is why I believe this is so cruel and it's so important to the American public, not just the federal employees, is that the idea that somebody doing their job for 20 years or 25 years has a political agenda, that you need to fire the employee rather than to just tell them do something else, that seemed to me to be fundamentally flawed.
Yeah.
Now, the second prong we brought with USAID is that many of the officials had also publicly talked about what I call the dinosaur comment, that these were older workers, they had a lot of pensions, they weren't going to really do anything, they were going to cost the government a lot of money, they were getting too much in the way of salary. And I think I am the only attorney who's brought this. I determined that really what that was an age-based discrimination claim. Because when the federal agencies terminated all these employees, particularly USAID, they gave them very limited notices of what their appeal rights were, and they said nothing about age discrimination. And that in and of itself is a violation of the Act. Under the Age Discrimination in Employment Act, you do not have to administratively exhaust. You don't have to go to the EEOC, you don't have to go to the MSPB, you go right to federal court. So we have a case in federal court. There was a third prong in USAID that came even before the other actions, and this reverberates throughout the government too, is they terminated the civil rights section and said that people were involved in diversity, equity, inclusion, and accessibility functions that the executive orders of the president targeted as the woke ideology. And if you read these executive orders, they're very pointed. They're basically opinion letters on how bad this is. The EEOC itself was, all their members were terminated, and they brought in new members who declared that DEIA itself was discrimination. When I got into USAID, those were the first people that go. I brought what's called a mixed case appeal because I argued that the termination of people for supporting civil rights activities was itself a violation of the Civil Rights Act. There's a battle going on right now because a Trump-appointed EEOC judge said no. We are in federal court in the District of Columbia. We did a lot of work on the DEIA case, and we found that it would probably interest the public to know that the vast majority of diversity, equity, inclusion, and accessibility was not directed towards minorities because they are already protected by the Civil Rights Act. The vast majority was towards people with disabilities. In every agency I've dealt with, the primary mission of the DEIA people was largely on the accessibility prong, the idea of bringing in folks with disabilities to work for what was supposed to be the model employer. So those are the strategies that I've developed with the USAID cases, and we're currently in federal court on 2 of the cases. We are before the MSPB, which has gone back and forth on how it's going to address our case. It finally ordered the agency after 16 months, and I think on one of our cases, we have a very thoughtful judge who has understood the arguments. But we are going to begin to get discovery from the agencies, and discovery for those that are federal employees. That's how you win a case. You get documents and communications that show that what was being said was different what's being said now. And finally, I've demanded depositions of very senior members of the administration. There's a battle going on right now as to whether they'll get them. So that's where I am on my legal strategy.
You answered a lot of my questions along the way. One thing I did want to follow up on, I appreciate your strategy. We do things slightly different and our role at our firm. So I wanted to talk, why should an average American, whether MAGA or not MAGA, care about what happened to the USAID employees? Like, putting aside politics, I hear people say, oh, why should all these federal employees get all these extra rights? So from your perspective, why should an average American care about what happened to USAID, regardless of politics?
Every country, every system that rewards loyalty over competence ends up in the same place. So whenever you have a spoil system of government, where I get this position not because of my competence or capabilities, but because of my loyalty, the services that government provides, the transparency of that government, and its responsiveness to its citizenry declines. And so what happens is you get agencies that are doing things not because they've evaluated it, looked at it, debated it. And look, that federal employment was designed to be bureaucratic under the Civil Service Reform Act. That's what Americans have to understand. We designed this system this way. It's slow, it's cumbersome, sometimes it's not efficient. We've all been frustrated with it. But if the response to that is to replace that with a system that rewards political ideology over competence, all you have to do is pick up a newspaper to see the impact of that in every aspect of federal government. We have measles now, right? Rates we didn't have before. We have food contamination, didn't have before. We have issues overseas that, had USAID been there, could have had an early warning sign, like Ebola. All of these things are aspects in my mind, and I'm not political on this. You can vote Republican, Democrat, Independent, Socialist, whatever you want to do. But every time you have a system that rewards loyalty over competence, your public services are going to decline. I became eligible at my age for Medicare, and this is supposed to be an easy process. I've spent at least 15 days on the phone trying to get people at Medicare to tell me what's covered, what's not, under what. And I'm an attorney. If I was a 75-year-old person trying to figure this out, I'd be very frustrated. The larger issue is the competence and responsibility and transparency of the federal service. There's a second aspect to this that should trouble every American. I know federal employees are not at will and they have rights we don't have, and isn't that so unfair? But you know what? Your private employer is looking over his shoulder to see what rights federal employees have. Because if I'm a private employer and I've owned a business, if I have a competitive marketplace that is assigning certain rights to employees, such as health benefits and other benefits, even though it's not paying what I'm paying, I have to at least match that. So the destruction of the rights of federal civil servants is part of a larger strategy of reducing the rights of workers overall. Look at the series of actions that been done by the Department of Labor and other places. The unraveling of, for lack of a better word, would be the New Deal. Average American will face consequences from this strategy. They are seeing them right now. Right? If you are wondering why we are doing things that don't seem to be well thought out, it's because we've gotten rid of the people who would well think them. And one of the things we see even in our justice system and in these lawsuits we're bringing is my favorite story in all of this USAID scenario was my first administrative hearing with a judge for the DEIA employees when the agency physically appeared and said, we can't answer the appeal because we fired all of our attorneys. And my response to that was, Your Honor, that's like the Menendez brothers complaining that they're. I mean, these are self-inflicted wounds. Like even with USAID, continuance after continuance, the number of attorneys that we have on these cases changes every couple weeks. And that is because a rapid turnover in your government, as boring as government can be, when you remove that body of knowledge and information and that sort of expertise, you're in trouble. If I go to a doctor's office, I'm going to look for the man or the woman with the gray hair that's been doing this for 30 years, right? I want expertise. If I'm going to hire an attorney, I want somebody who's been doing this for a while, knows what they're talking about. The Civil Service Reform Act was designed to create that body of competent, technically proficient, absolutely boring civil servants that would just answer all your questions in these pedantic ways, and it bugged you. But right now you have people that can't answer your questions at all, or are just not responding to you. And ultimately, I think the American public will pay a heavy price for that. And as much as it's fun to make fun of federal employees, by and large, the strength of the country and the government has largely been predicated on the competence of its military, the competence of its civil service, the competence of foreign service, the competence of its national security individuals, agents. If you remove that, one just looks at the headlines and says, why is this happening? Because you caused it. There is a cause and effect.
Yep.
So that's why I think this issue is much larger. And I will say for me, on a personal note, it has been absolutely exhausting to take on the administration, often take on other groups that I would have thought would have been ideologically supportive that have their own agendas. That's fine. Watch law firms cave, watch federal employees lose heart, not even bother to fight because they think it's pointless. And actually, on a human level, listen to the pain and agony of people who spent 20 years or 15 years doing something that they thought was making a change for the better in the world, who simply got fired and were told that not only were they getting fired, but they were engaged in all sorts of illegal activities, and some of them are branded, they can't be rehired. I find that just as a person disgusting. And I've made the commitment that I'm going to use my skills to try to oppose that.
What I like to say is this is what I think it must have been like for medical practitioners during COVID, what some of the doctors felt like. So your point about administrative leave, like they used to tell us all the time in mediations that they can't go that long, that there's a regulation about that. And then things just changed and now they can do it. And we also have someone here today with us, Lillian, who is one of the people who was affected by all of this. And she's been helping out. She's part of a fund that I wanted to help people get more information about. So Lillian, thank you and welcome to the show. I want to talk about the fund a little bit first and then your experience going through this. I mentioned there's a USAID Employee Support Fund. For listeners meeting the fund for the first time, what is it and what gap were you trying to fill when it started?
Employee Support Fund exists to help finance the legal defense for the lawsuits that USAID civil and foreign service officers have put forth with the MSRB.
Could you tell us who does the fund serve and what is its role in the ongoing litigation?
Sure. So the fund supports USAID foreign and civil servants employees who were separated with the dismantling of the agency in 2025. The fund itself is being used to support the individual lawsuits that these employees have put forth against the dismantling of USAID for various reasons.
And I do think it helps to hear individualized stories of what happened. In a broad way, people can politicize federal employees sometimes, swamp people, right? Which is wrong because federal employees come from all political backgrounds. They're real humans, veterans. They go to Target just like normal people. So I wanted to talk a little bit about your experience. Can you take us back to when you first realized your work and your agency itself was in real jeopardy? And what did that feel like at that time?
I received an email saying we're being placed on administrative leave. Didn't really know what that meant or what the impact would be at that point in time. So had conversations with our ambassador at Post to say, what does this mean? How should we move forward? Talk with my mission director to see what this meant. Originally, I was the director of my health office. I was the only American in our team. And so I was sent home originally for 2 weeks, but was allowed to come back to help with the dismantling of our office. And what that meant was having conversations with our grantees to say, unfortunately, we will no longer be funding you. I know that we have individuals on life-saving medications that we're providing them, but this has to be transferred over to the Ministry of Health or to another partner because we will no longer be allowed to fund those activities. And then had to look at my staff members and says to them, yes, I know that you've been with the agency for 20, 10, 5 years, or you just quit your job because you thought this was a great way to help your country or working with the US government. But unfortunately, you no longer have a job either. How can we help you? What are the systems in place within the local government to help you transition to find employment? Well, at the same time, colleagues that I had sat with months prior all of a sudden didn't know my name, didn't want to talk to me. The amount of information that was put out about us as employees and what we were doing, it didn't just impact us, it also reverberated throughout the diplomatic community overseas.
Is there a moment from that period that still stays with you? Something that captures what was actually lost beyond the headlines?
At the time, she was 8 years old,
Yeah.
and she had pretty much grown up overseas her entire life. And so sitting down and having to tell her that unfortunately we would be leaving Botswana. And her question was why?
Mm.
Why did we have to leave? And I had to tell her that the president felt that the work that we were doing was no longer valued and
Mm.
that the money should be going to do other things. And her response
Mhm.
to me, I'll never forget, was, but you're helping people, you're helping sick people. And I was like, yeah, but unfortunately, that's not something that president says that we should continue to do in the capacity that we're doing it as USAID. And so she was so upset. And I had to dedicate it to her that we would be packing up our bags and we would be going out to Washington and trying to figure that out for myself, but also trying to relate it to an 8-year-old so that she's not worried about where are we going to live or where am I going to go to school, but also trying to have those questions for her to prepare her for what was happening and what was going to happen. It was really challenging. So we very unceremoniously and to want us to leave with our head hanging low. My boss goes, no, you came down, you worked, you did great things, and we're going to keep our head held high. I think for me personally, if I had done something that caused me to lose my job, I would accept it. I would say, okay, this was a result of my own actions, but I think the fact that this happened as a result of no fault of my own, it was a decision that was made. I'm a foreign service officer, so I've been with the agency for over 15 years. There's sort of a process that's supposed to take place when employees are terminated as foreign service officers. Not only was I the foreign service officer, I was not only tenured, I was also commissioned by the US Senate. So there are certain regulations that were supposed to take place, and those did not happen. And I think that this is one of the things that the support fund is trying to assist employees with, is that these actions were taken by no fault of our own. And so we want our day in court. We want to hear the individuals who made these decisions explain how they were able to make these decisions not in accordance with laws that were already in place to protect not only the government, but also our employees.
And you just shared your story, but it strikes me this has happened to 4 or 5,000 people around the same time. And so just to think, regardless of what you think of politics, people should not be treated the way that people were treated here. And you mentioned the fund. I was wondering what comes next for the fund and the employees, and what do you most want listeners to do after they hear this episode?
I would really encourage listeners to go to the USAID Employees Fund.org website learn how they can assist or get the word out about just the fine and this concept. My understanding is that we are some of the first cases by the agency that are being brought before the MSRB. I believe the next stage for us as employees is that we're looking forward to the depositions of individuals. I know that Kevin is working with his team at Patriots and with us as clients, come up with a list of who should be deposed and what information they can gather through depositions. I think we're just sort of gearing up for our day in court or our day before the MSRB.
Well, thank you, Lillian. We certainly wish you the best. And I do know lawsuits take money. So if this is calling to you, I'd encourage people to learn more about the fund. Check out the show notes. We'll also put a link so they can learn more about it when we send this out to our newsletter. Hopefully, this helps you get the word out even more. Thank you so much, Lillian, for your time and sharing your story. Thank you, Kevin, as well, for your time and helping our listeners understand a little bit more about what's going on before the Merit Systems Protection Board. I appreciate both of your time. And again, everybody, if you're interested in supporting the fund, please check out our show notes. Up next, we have the Ask Shaun and Lydia section. We'll take your questions there, and we'll see you shortly.
So now it's time for Ask Shaun and Lydia Anything, the segment where you get to be in charge. So keep in mind that you can always send us your questions at advocate@Southworth PC, or of course on any of our social media platforms. You can send your questions there as well. No questions are off limits because if you are wondering, 1,000 other people are wondering too. So we picked a couple this week and they both come straight out of today's episode. So here's our first question. So, Shaun, I'm going to kick the first one to you. I have a RIF case from last year and it is still pending. If RIF appeals move to OPM on September 2nd, does my case still get pulled out from in front of the board?
People have all these RIF appeals. They want to know now what's going to happen next. Is there any chance that now it's going to go to OPM? And great questions to think outside the box on this, but this is one of the ones where I think your intuition is probably right. So good news on that. The dates are on your side there. If it's
Yeah.
already pending before the MSPB, no change. There is this little bit of time period between basically up until September 2nd where you need to rush in to the board. But after September 2nd, then at least for a while, it's going to be before OPM. I'm sure there will be legal challenges, but you're safe basically at this point. If you already have something before the board, all of our RIF cases, not worried about that. I do honestly think if they do RIFs again, it'll be very disappointing, but for everybody already at the board, you're safe. So that is what I think about that.
All right. So the next question is mine, and it may be the most important question of the day. And we have talked about this before. This question says, guys, I want to appeal, but I can't afford a lawyer right now. Should I wait to file until I can? And the answer is a resounding no. No, no, please do not wait. File on time. Go through the e-appeal system. The system exists exactly for this reason. It is user friendly. You do not need a lawyer to file your appeal. Please make sure that you file your appeal timely. You can always hire a lawyer afterward, but the reverse never works. You cannot hire a lawyer if you've missed the deadline, but you can certainly make the deadline and then hire a lawyer after.
Yeah. And the other thing I would say there, try to get an attorney as soon as possible, but we will take cases that have already been started. If you file an MSPB case, the biggest thing to watch next, the acknowledgement order, like we said, read that closely, try to initiate discovery on time. That said, if you already know you can forward an attorney, that doesn't mean do stuff. If the deadline hasn't passed, get the attorney first.
Yeah.
Well, to your point, don't wait, because if you're waiting for an attorney, you miss the deadline, you're done. And yes, you can reach out later. Obviously, if you can't afford an attorney, you can't. But if you can later afford one, then you might want to reach out at that point.
Yeah. And we certainly don't want to minimize legal fees. We have no shame in admitting that legal fees are expensive. But keep in mind, guys, that if you appeal your case and you win your case, then you can get your attorney fees back through the agency if you get a judge's decision or through a settlement as well. So just know that the monies that you spend on the front end for attorney's fees will be really helpful on the back end in getting those fees back.
Absolutely.
Yeah.
And not every case, of course, but that's why we say the stronger the case, the more likely you are to win. The more likely you are to win, the more likely there's going to be fee shifting statute and your attorney's fees are awarded.
Absolutely. All right.
So I think that's it, Lydia. We've done it. Episode 5 is in the books.
In the books.
Yes. Episode 1, we told you to build the file. Episode 2, the record. Episode 3, the clock. Episode 4, the accommodation fight.
Yeah.
And today you saw all of it, where it sometimes goes for the big stakes stuff in federal employment law, the board, the MSPB, where the agency finally has to prove it under oath
Yeah.
in front of somebody who doesn't work for them.
Yeah. And to anyone who's listening who's been separated from their agency, whether it's USAID, the State Department, or anywhere in this government, I hope today that you heard one thing above everything else. The fight is not over just because you're holding a letter in your hand that says it is. There is a door and there is a clock. And our guests showed you today that there are people still walking through that door right now. So you're not alone in this.
And cases are continuing pretty well before the MSPB overall. So, Lydia, as we wrap up, this show started with a 7 a.m. phone call in January of 2025, I think. That's when we called you, hey, we need to get information out. People are scared, and it's kind of led to this process. We're now on episode 5. Still not perfect, so give us your feedback, everybody, but enjoying making this content, getting good feedback from you. Before we let you go, I just wanted to thank everybody who listens for your support, everybody who follows us on social media, helps amplify our voice. If the show has helped you, please leave us a 5-star review again, wherever you listen, and share it with someone you care about. We set up an easy link to do that. You can just send them to fedlegalhelp.com/podcast. And again, be sure to subscribe so the next episode comes to you automatically. And for those who don't know, our firm publishes a free daily newsletter for federal employees. About 4,000 feds read it every morning, fedlegalhelp.com/newsletter. You don't even have to put in your name anymore, just your email address. It takes a few minutes to sign up. And that way you're always kept in the loop. You can just look quickly at the message, keep on getting it, so you don't have to rely on the algorithm to get you stuff. And please also be sure to check out the show notes if you are interested in supporting our guests and the USAID Employee Support Fund.
Awesome. So thank you guys again for spending part of your day with us. We are proud and honestly humbled to make this show for the people who keep our country running every day. If you are ever in need of an attorney to help protect your service, we hope that you'll consider working with us.
Because we do believe your service is worth protecting. So let's protect it together at Southworth PC. Thank you, everybody, for your time and support. Have a great rest of your day.